Okay, how many people have actually conducted a closing tonight? Okay, so there's a fair amount of you. So a lot of the information that you've already seen in your pamphlets is pretty basic knowledge, but as I attend closings, and it's the first time for a lot of attorneys doing these closings, I try to hit the highlights and most important issues that seems to cause a lot of commotion and disallow the closing from being as smoothly as it can possibly go. You guys have probably been in closings of that nature where they have asked their attorney that's done their will, or I know a friend down the street, he may practice criminal law and they want them to handle the closing. And it's difficult because a lot of the regulations that we encounter in the banking and mortgage industry are changing, which seems like on a monthly basis. A lot of the main documents that you'll see don't change, but there's some key terms that I want to highlight and make you aware of as we go through the process tonight, so that it makes that process a little bit easier when you're explaining it to your clients purchasing or selling a home. So first of all, I just wanted to bring you through the closing process. You've gotten the clear to close from the bank, which is the biggest hassle these days. Underwriting requirements, as you all can imagine, are extremely stringent nowadays. You could have the best credit scores in the world. You could be buying a small piece of property. It could be vacant land. And the underwriting requirements are extremely difficult to maneuver. So one of the things I caution my clients when I talk to them in the very outset is patience. Managing your clients' expectations throughout the process, even more so in the very beginning, is extremely important. A lot of people may have gone through the process 15 or 20 years ago, and it was really a couple of pieces of paper, a handshake, the keys were handed across the table along with some checks, and they were out the door. And it took them 30 days to get there. Those days are no longer with us. The typical closing you can expect to take 45 to 60 days. More often than not, when a short sale's involved, that process can be 6 to 9 months, depending upon who you're working with. So if you've made it to the closing table, consider yourselves lucky. That's a good thing these days, and now it's trying to put all the pieces together. Obviously, you want to invite all the correct people. Don't forget your title agent. Don't forget your real estate agents. Make sure all the attorneys are on board, and have everybody there ready to go and prepared to present the checks and go over the closing numbers. One of the documents that I have highlighted in the back of the materials is a statement of sale. And if you turn, it's really page 5 in your materials. Very basic. You don't need much more than this to get everything squared away with your client. It's a typical closing statement with the numbers for the seller, the credits to the purchaser, what checks need to be written, and the expenses that are outlined at the lower left-hand portion of the paperwork and the lower right-hand portion for the seller. So it's outlined quite easily of what you need to do. It's filling in those blanks ahead of time. A lot of that information is gleaned from the contract, including the purchase price. Some of the information that you need for that comes from the title report, including the tax adjustments. The biggest issue when you're dealing with tax adjustments that you see on that, the credits to the seller, the credits to the purchaser, where you have the county and school taxes, are the different municipalities that are involved. I don't know if anybody's done a closing in Schenectady County recently or in Cohoes. They have totally different tax years than the rest of the capital region. So trying to figure out where you fall in those tax years is pretty difficult, not to mention the school tax itself. It follows the school year, not a fiscal year. Where the county tax follows a regular 12-month calendar, it's easy to plug in those numbers and adjust how many days are left in the calendar year. The school tax runs from July 1st to June 30th. So in this time of year, you're dealing with only 12 days of adjustments as a credit to the seller, and then 120 some odd days for the county tax through the end of the rest of the year, 190 days, I'm sorry. So you really do have to pay attention to that title report when you get it to try to fill in the blanks. And I see a lot of mistakes that are made that you fumble through the paperwork at the closing table trying to make the necessary adjustments when it comes down to the county and school taxes. Because if you're doing Saratoga closings, Saratoga County closings, they may be a little bit different than Schenectady County closings. So just something to think about when you're putting the statement of sale together before the closing and ready to present it to your client. You want to be as accurate as possible as far as the numbers are concerned. I know from my point of view, I went to law school because I wasn't a math person. I'm doing real estate, so I see numbers all the time now, so it's been counterintuitive, but you get used to it, trying to pick out the right numbers to go in the right places. But if you have a great paralegal like I do, they can also be a benefit to trying to plug those different things in there. So that's one of the first things I would talk about is the county and school taxes and how to adjust those as far as getting your closing statement together. Another item, believe it or not, that causes a lot of commotion is the water and fuel readings. More often than not, when we're getting the numbers together for a client, these are the last figures to be placed in the closing statement for a variety of reasons. People don't have fuel adjustments all the time. Not a lot of people have propane tanks to heat their homes or to fuel their homes, or oil tanks. So a lot of times people forget to make sure that those readings are taken care of ahead of time. So as the attorney, you show up to the closing table, somebody asks you about any fuel adjustments, and you're left holding the bag trying to figure that out. But it's a small figure. It's usually can be called in and done and adjusted for within 48 hours, but that's one of the few items that does cause a last-minute hiccup along the way if it's not done properly. The same thing goes for the water adjustment. The numbers that have to be called in, usually you can do it 3 or 4 days in advance. Sometimes I lean on the realtors to help me out and get that taken care of. And the biggest thing is explaining that to the purchaser when they receive the credit. So the bill's not due for another couple of months. The closing happens today. The purchaser is going to get a credit for that water reading, and it could be $50 or $60 for usage that the seller's already taken care of up until that closing. So there's a period of time the sellers use the water, the bill hasn't come out yet. Believe it or not, I'll get a call after the closing about $50 that I'm being charged for. Why am I being charged for the seller's water usage? I remind them they got a credit for it on the statement of sale. It was adjusted for at the closing. So $50 or $100 on a $300,000 or $200,000 purchase causes the most commotion all the time. And surprisingly, I try to bring that up, and I'll still get a phone call tomorrow on the closing I did this afternoon for that very same reason. But those are some of the two adjustments that take place. The other thing that people have trouble with are real estate commissions, making sure that they're on the statement of sale, and trying to make sure if you're representing the seller that everything that they had agreed to as part of their listing agreement is accurately reflected on the statement of sale. So what you want to do is talk to your realtor ahead of time, make sure they get their commission statements to you ahead of time. You can adjust for them at the closing, and you want to make sure you talk to your client to figure out it's supposed to be a 5% commission. How is it supposed to be split with the co-broke commission? So it could be a 6% or 5% commission split evenly. I've seen it 3%, 2%, or 4%, 2%, but you want to make sure your client understands exactly how they're required to pay their realtor at the closing table. And a lot of times they don't know. It is restated in the purchase contract in one of the standard Capital Region multiple listing agreements. It's in there. It should be stated there, but you should also check with your client to be sure that that is in fact the right amount. I see I haven't flipped any of the slides here. The next thing to talk about is title insurance costs. Does everybody have a basic understanding of what title insurance is? Yes, sir.
Before you go on, I want to ask you a question about the tax adjustments. Is there any regulation you're aware of that determines how many days are included in a period? For example, if you close at noon on a particular day, does that day get included with the seller's proration, or is it included with the buyer's? Well,
believe it or not, it depends on, first of all, what time of the tax year you're in and if the taxes have been paid. So if the seller's already paid the tax, they're going to get the credit for the payment. Now, determining how it falls on which day, if there's an extra day involved, it depends on the attorney and on a case-by-case basis. Usually we look at our numbers and we figure out if it's closing before noon, you probably don't get the benefit of that extra day. If it's closing in the afternoon, A lot of times it's just included by just common courtesy and practice. So
that's sort of my question. Is there anything that says how you have to treat it?
it really isn't. No, it's just practice in the area in which you practice in. So common practice and courtesy between the attorneys usually figures those things out. Yes?
How do you handle school taxes in July and August, since the bill doesn't come out until September?
Normally what's going to happen is you're going to take an estimate of what that cost could be. Two ways. One, you're going to take an estimate of what the cost is going to be. Or the other way is to use last year's taxes. More than likely, it's going to be a bill held by the title company in escrow until that becomes due, and then the credit's going to go to the purchaser. So let's say, for example, the last year, 2011, the school tax for that house was $2,000. And we're closing in July after this one's already been paid, waiting for the new bill. Title company's going to hold, it could be 20% or 25% in escrow. So based upon last year's taxes, you're going to assume that that bill is going to be paid by the purchaser in September or October. The purchaser is going to get the credit on that section of the statement of sale that's on page 4 or on page 5, and then you're going to adjust for it that way. And they're also going to, it's going to come out of the purchaser's proceeds to pay that tax bill being held by the escrow company till September or October, when that bill actually becomes due. Does that make sense? I know it was a long-winded answer to a very complicated question.
There is another way I've seen, and sometimes people actually do an escrow for the tax bill until it comes out, and then adjust depending on whether there's too much money or too little money in there. Somebody pays and gets a refund.
Right, based on usually when the escrow company holds it for 25% above that $2,000 amount. I luckily haven't seen the taxes fluctuate that much. It might go up 3 or 4%, and the remaining balance goes back to the purchaser because it came out of their proceeds. Good point. So the other thing that it causes a little bit of complications is title insurance. First of all, I asked the question, did anybody deal with title insurance or understand the basics of title insurance? Depending upon who you ask and what role they play in the closing process, they may have a difference of opinion on what it's all about. It's only good if you need it, some people would say. Some people would say you can never be overinsured, so it's not a bad thing to have. Regardless, if it's a finance closing by a banking lender, you're going to have to pay what's called a mortgage policy. Within that mortgage policy, there's search fees, premiums, endorsements, those types of costs that the purchaser is going to have to bear, with one caveat. If you're in Schenectady County, they still go by the old school version where the seller is going to pick up the search fee as part of that title insurance cost on behalf of the purchaser. The purchaser is just going to be responsible for any premiums, endorsements that go along with that overall cost. But what is title insurance and what is it necessary for? It's basically to protect against future defects in title that may not have been picked up in the current search that was done prior to the closing that you're all attending. There could be judgments, liens, that sort of thing that are not picked up, that were misfiled. Title insurance would protect the bank up to the full amount of their mortgage, and then if the purchaser buys an owner's policy of title insurance, it would protect them up to the amount of the purchase price. So that's why you see that there, and it's one of those things that you want to bring up at the outset, because to assuage your client's concerns about what it's used for. Why do they have to pick up the tab for the bank? Well, it's a requirement of your loan. You're not going to get the money unless you have a mortgage policy in place for your bank. And to let them know what the owner's title insurance is all about. If you don't recommend owner's title insurance and they've never heard about it, and something comes up after the closing that affects their title to the property, you could be on the hook for a wonderful malpractice claim if you've never mentioned owner's policy of title insurance. That's why at every closing, the title agent's going to hand over an affidavit that says, we all gave this purchaser the opportunity to buy owner's title policy, an owner's title policy, and they refused or they bought it, and there's other things that go along with it. But I always bring that up at the outset, even when I first introduce myself to the client, because it's an added cost at the closing to pick up the tab for an owner's title policy. They've heard difference of opinions, so it's trying to lay the groundwork for when the closing actually occurs, what goes on as far as title insurance is concerned. Yes, sir.
20 years ago, I worked for an attorney that says it's malpractice not to recommend they get it.
Correct.
Do you recommend to every client that they get it?
Or
do you just notify them, or do you recommend it?
I notify it, and I say the reasons that are good, bad, or indifferent to get it. I tell them it's a business decision on their part. I say that the percentages of people that do get it, I don't necessarily like to say I recommend that they get it, because I don't want to be tied to a relationship with a title insurance agent, and then you get into all those other wonderful questions. But it's a fine line. But you definitely have to offer it to them. You don't necessarily have to recommend that they get it.
Now, how often do you see a title problem where you would need title insurance?
I see more and more now that there's foreclosures going on, bankruptcies. Those are the riskier propositions that come out there. 20 years ago in upstate New York, it's maybe 1 out of 1,000 closings. Very small, very small. Downstate, New York City, nobody leaves the closing table without it. They, not only do they offer it, they recommend it, and they force you pretty much to get it. Because it's just like the wild, wild west with the county clerks and how things are filed down there and handled. And you can imagine with all the properties in one small defined area, the different types of issues that would arise. But upstate, fewer and fewer issues, but more and more prevalent nowadays with the mortgage crisis that we just have been going through right now.
Just one, what would be an issue in title that you would need it?
An issue that could pop up, or where I would recommend.
I mean, when would a policy ever pay off? What sort of problem would come up that you would pay off a policy?
When I go through the owner's policy of why somebody should or should not get it, I tell them there are some risky propositions. One, if there was a bankruptcy close in time with either the current owner or previous owner, because some of the judgments that follow that bankruptcy may not have been filed correctly. So you run into some issues where misfiled on the property comes up later on. As the current homeowner, they could be responsible for that. Anything with a trust and estate where you have to have notification requirements to heirs. Some heirs may have been missed. There may have been adopted children that weren't notified. We have no way of knowing that, but for a small price, this will protect you in that event. Those are the two main areas. And if you're putting down a huge amount of equity into the home, if it's a cash deal, or you're putting over 40%, 20%, different schools of thought on that. But if you're putting a huge amount of equity in, small cost of title insurance can get you a significant peace of mind after the closing for those types of scenarios.
Thank you.
Sure. That's the title insurance aspect of it, but I could spend probably a day and a half teaching a course on title insurance alone for the reasons we just went over. It's an interesting topic. There's different schools of thought on it, but it's good to bring your client on board early on to try to figure out where what questions they may have. They may not know anything about it, or they may have an opinion about it. It's good to talk about it at the outset, especially since it'll be an additional cost to them as far as picking up their owner's policy. Next thing that causes some commotion at the closing table that I see on a daily basis is dealing with mortgage tax and transfer tax and deed stamps. Mortgage tax, I guess I'll preface it, mortgage tax and transfer tax. New York State gets you coming and going. If you're taking out a mortgage, you're going to pay tax on it. If you're selling the property, you're going to pay tax on that in some way, shape, or form. With the mortgage tax, that's the buyer's responsibility. And again, depending upon where you live, where the property is located, you're going to pay a differing amount of the tax. Usually, it's 1% of the mortgage amount, and it's split between the lender and the purchaser, 75-25. Usually 0.75 to the purchaser, 0.25 to the lender, and that's paid at the closing table as part of the process. As far as the transfer tax, you file a form, the TP 584. You pay $5 to do that. There's a 4-page form in the back that goes through it that the purchaser and seller sign verifying the purchase price. So if you have a $100,000 property, it's $4 for every $1,000 in the purchase price, so you're paying a $4 or $400 tax on that transfer responsibility on the seller. But yeah, they get you coming and going, but that's the cost of doing business in New York State. The other things, again, are all fact dependent upon where you are. How many pages in the deed, that's going to cost you a little bit more. Usually the standard document's 2 or 3 pages. Some municipalities have a $45 cover page fee. These are just easy things to miss if you're not used to the municipality that you're closing in. Recording the mortgage, same thing. It's a per page fee, $5 plus a $45 filing fee for the document alone. Same thing for powers of attorney. Used to be a 2 or 3 page power of attorney. Now we use the standard New York State form. It's 6 pages, so that cost doubled from $15 to file to now it could be $60 to file. So there's all these different recording fees that you have to be aware of. Your client has to be aware of. There's a closing tomorrow that I'm going to. Borrowers are strapped for cash, and every little detail that they're not expecting when they get to closing, that they weren't expecting, and we'll talk about it, that wasn't disclosed to them on their good faith estimate, is going to upset the apple cart quite a bit. And you have sellers that are bringing money to closing these days. You have purchasers bringing as much as they possibly can to a closing, which again is a whole other topic that we can get into. But all these little things add up, and if we're not aware of it ahead of time, we don't do the calculations correctly because we're not used to the county that we're closing in, that could cause $50 to $100 difference, which to you and me might be something, but to the borrower or to the seller might mean a whole other thing. So just some food for thought on the little things there to be aware of. Now the next item, this one is the HUD-1 settlement statement, and you can find it in the back of your materials. It's a 3-page document, and it's right after the statement of sale that we showed earlier on. Believe it or not, this form has been revised in the last couple of years, and in my personal opinion, it's gone from bad to worse. The government tried to get involved, the federal government tried to get involved and want to make a document that was complicated to begin with be a little bit more clear and understanding as far as the borrower is concerned, and I just don't think it does it right by the borrower. I think it just lends to the confusion. Before, simple document, and I tell my clients all the time, listen, here's my statement of sale, that first form we went over. Look at this one. This one has all the numbers between you and the seller. Now we're going to see the document that has all the bank's numbers as well. And so you have borrower's numbers, the seller's numbers, the bank's numbers, numbers that the borrower saw in their good faith estimate, and they're redisclosed on this form. And then you get to page 3 of that document itself, the very last page where they have to sign. Here's your good faith estimate again. Here's how well the bank did in estimating those costs. So there's a lot of stuff going on. And for somebody that's done it for the last 9-10 years, that's one thing. Even when this came out, extremely confusing, not only to set it up when we represent the bank ourselves, but trying to explain it to our client. I mean, they want to know what's the bottom line, and then you throw a 3-page document with, I don't know how many numbers can be on here all at once, but it seems like it goes on and on. They tried to do the right thing in making it clear to the borrower and redisclosing the information, because a lot of this information was just done at the beginning of the application process. When you first applied, you get the good faith estimate. There'd be that APR on there. Again, we'll talk about that at the later portion of the program. And then they'd maybe not see it. They'd sign a form at the closing. So now you see it in the beginning of the application process. You see it when you've been approved for the loan, and then you're going to see it again, all these numbers at the closing table when you sign the HUD-1 settlement statement. So I guess if you disclose it enough, it kind of forecloses the idea that somebody can complain they didn't see the number. I mean, they've seen it 3 or 4 times by the time you get to the closing table, but the problem is everybody, or maybe all of us, have been through a closing, even on our own purchases. You're at the closing table, you're signing everything, you're listening to your attorney, the other attorney's going, and now they're redisclosing these numbers. I don't know how much of this is actually sinking in at that point. Probably not a lot. So you're still losing out on the important information. But the biggest thing that you want to point to on all of this, you've already gone over the numbers, the majority of them on your statement of sale. This one is just to give you confidence before you start signing the next documents we're going to talk about. If you look at page 3 where it says loan terms, it goes through and itemizes everything, maybe for the first time for your borrower, what the initial loan amount is, what they've agreed to. Hopefully they've seen that with their commitment letter, how many years, what the initial interest rate is. But if this is filled in correctly, Everything else your client is signing at the closing table, if you're representing the borrower, is going to play off those numbers. So you're going to have the initial loan amount, number of years, the interest rate, whether there's a balloon payment, whether there's prepayment penalties. So when I sit down to a closing, I immediately pull out this HUD-1, check with my client, hey, you're getting a 4% interest rate. Here's your principal and interest. It includes mortgage insurance. These are the general terms about your loan. Does this sound right? And if they haven't fallen out of their chair, I think we're okay to continue with the closing. But believe it or not, a lot of times there's surprises. The bank hasn't told them exactly what their loan terms were. They weren't expecting the PMI to be in there, the mortgage insurance, and so their payment, therefore, is a little bit higher, which also talks about the escrow amounts in there. If they weren't expecting the increased taxes on a property that may have just occurred recently, so the interest or the taxes that you're paying into the escrow account as part of your mortgage payment may have changed recently because of the increase in taxes, that may throw off their mortgage payment on a monthly basis and be a complete surprise for your borrower. So HUD-1 settlement statement, it's been revised. I don't necessarily think it's new and improved, but there's a lot of terms in there that you need to familiarize yourselves with in order to present it to your client in a coherent fashion. Any questions on the HUD-1 settlement statement?
Just in general, I've never done one of these before.
Sure.
Are all these prepared by the seller's attorney?
There's a number of forms that are taken care of by the bank attorney. The HUD-1 settlement statement is the one that's taken care of by the bank attorney. Usually, to formulate that form, your statement of sale is taken care of. You do your statement of sale for the borrower. The sellers do their statement of sale, combine it to get the HUD-1 settlement statement. And then there's a division of who's responsible for what. The one form that you file as far as the transfer tax is concerned is a seller's responsibility. There's another form that's a borrower's responsibility. But usually, talk to the other attorney. They'll let you know who's responsible for what, just so there's no miscommunication. Usually a lot of these forms are found online anyways, so if you forget one or you don't prepare it ahead of time, a lot of this can be done at the closing table, except for the closing statements. Those are the most important things that you'll prepare ahead of time if you represent the borrower or if you represent the seller. You should all have your own statement of sale. But normally you talk to each other beforehand, make sure your numbers are on the same page so your adjustments are correct and all your fees are correct, and then you can get to a similar bottom line by the time you get to the closing table. But everybody does, they all have their own responsibilities, not just one attorney. Is another hand up?
Yes. Are the electronic versions of these forms, are they computer forms you have to buy, or are they for free at some sites on the net?
Most of these forms, including most of these forms that we go over today, can be forms online. The government, the state government, as far as the TP 584, the one where the seller's transfer tax is mentioned, that's a form downloadable from the state website. There is one form that you have to order. I don't think we've talked about it yet. We're getting to it on the next slide. The E&A Form, the 5217, which tells the assessor's office that a transfer is taking place. That one actually, it's been improved over the years, but it's still in triplicate, believe it or not. So you have to order it, have those forms shipped to your office. So if you're the purchaser's attorney, you can have that ready to go at the closing. But those are free of charge. They'll just be sent to your office and taken care of. Everything else, if you're a purchaser or a seller's attorney, all the other forms that we talk about, for the most part, are handled by the lending attorney. And they'll bring those to you to the closing. But the ones for purchasers and sellers' attorneys, those are normally can be found online.
Can you enter the information on them, or you just printing a blank form with
The
have to type on it?
Yep, the TP 584 is a PDF document that you can fill in right online and then print it out. The E&A form, the RP 5217. Let's see here. Might be on a different. The RP 5217 that tells you the assessor's office, that the transfer took place and what parcel of property is being transferred. That's the one that's in triplicate. You'll have to handwrite it. You can type it out too if you have an old-fashioned typewriter, but it's not a fillable form. Well, hey, nope, not a problem.
It's an electric.
Yep, hey, I got one too. Got one too. For all these different forms, it's easier to do it that way, for sure. The next thing that I wanted to hit on that people don't realize, school tax relief forms. Everybody is eligible for school tax relief. It's free money from the government. So anytime you're purchasing a primary residence, your client is eligible. And then there's enhanced STAR. Hopefully everybody's aware of these different programs that are out there. Even just on your own residence, make sure these are in place, because anytime the government's handing out reduced taxes, sign me up. There's a form online that you can download. Even if you just Google it, it's online, New York State STAR form. It's a fillable PDF form you can do on your computer. There's also enhanced STAR, depending upon your age and income level. And then if you're a veteran, depending upon your type of service, you'll also be eligible for significant tax benefits through the STAR program. That's only on your school taxes, but it's a form I hand out at every closing. Anytime I'm doing a purchase closing, I hand it to my client with a copy of the deed and make them aware that that form has to be filled out and submitted to the assessor's office with the school district by March 1st of the next fiscal year. If it's not done, you're going to have the most school tax you can possibly pay be part of your escrow payment if you're financing it, or be part of your school tax liability each and every year. So the sooner you get it done, I tell them go right after the closing, sign up for it, take care of it right away. That way they'll be eligible. And believe it or not, your bank, if you're financing the home loan, the bank automatically assumes you're not going to apply for the STAR, so they base your escrow payment for your school tax responsibility on the higher rate. So as soon as you apply for the STAR, you notify your bank escrow agent so they can reduce that. And then you're also going to obviously notify the school finance department that you're eligible for the STAR, so you get that reduction right away. So it's free money out there. Anybody that has a primary residence is eligible for it. So definitely sign up as soon as you can. So those are the main non-lending, non-bank documents that I talk about as part of the closing to be aware of before you even get there. So you get to the closing, and then one of the things you want to do right off the bat is take your statement of sale that you've drafted ahead of time, compare it to the HUD. Usually ahead of time you've done this with the bank's attorney, making sure that your costs are on there, the seller's costs are on there. Check the contract. A lot of time there's in the contract there's a seller's contribution, seller's concession that you want to make sure that's included. If you're representing the borrower, they get obviously a reduction on what they owe the seller. Compare your version to the bank's version, and usually if everything's done right, everybody agrees to the penny, and you move right along. But that's one of the things, as soon as you get to the closing table, you want to take care of. So you've gone to the closing, you've gone through everything. Some of the things you want to think of after the closing that pop up, I know it might be small to read up there, but it's in the materials. Escrow for repairs. If there was any agreements made ahead of time that haven't been documented on your statement of sale, there's credits to be given for repairs that need to be taken care of. If the seller is going to be occupying the property for a couple of days after the closing, make sure that agreement's taken care of. Those types of things do pop up on occasion. You want to make sure those are ironed out well in advance. And also get as many copies as possible. My office, we scan everything in to make it convenient. It's always good to have a copy of all the checks, payoff letters, deeds, etc. Because when your client, if you're representing the purchaser, and they go to sale down the road, and there's a document that's missing that they need for their closing, somebody should have it. We're required to keep our documents in place for quite a period of time, so we should always have something from the purchase on hand. I don't know how many times I've gone to a closing on the sale and the satisfaction of the buyer's previous mortgage hasn't been taken care of. So if you have the copy of the check that took care of that payoff or the actual satisfaction document on hand, that always can clear up a title issue right away. Important bank documents, and a number of these are going to be in the back of your materials as well. The note in the mortgage. If you have done a closing in the last few days or in the last few years, little has changed about the note in the mortgage. You just want to make sure that they match up to the terms that we went over on that HUD-1 settlement statement. There's the loan, the terms of the loan, how much the borrower is taking out, the interest rate, and when the first payment is due. You want to check on it. The note, it's the IOU to the bank. They've agreed to loan you a certain amount of money. You agree to repay it. It's going to stay in place, and if you default, that makes you personally liable to the bank for any difference if they go to foreclose on the mortgage that you've signed and there's a difference in the sale price and what you owe on the loan. That note is going to hold you personally liable. Now the mortgage, I tell my clients there's 4 things you need to know about the mortgage, and there's only 4 things because, as I've stated before, if you want the money, you have to sign it. We can't change the language of the mortgage that the bank is giving you. As long as you pay your principal and interest on time to the bank every month, you pay your taxes on time, you keep your property insured, and you take care of the property, you're completing the 4 requirements under that mortgage to make sure you can stay there without the bank ever giving you a problem. The minute you miss one of those 4 requirements, nothing in that mortgage can help you out of that situation. I tell my clients that at every closing. They seem to understand it, and that gets them to page 10 awfully quick because, again, the bank takes 10, sometimes 16 pages to let them know that they can't store old tires on the property or hazardous waste, and if they do, that's a default. Banks in the mortgage say they can come and inspect the property, make sure you're taking care of it. They never do, but nothing in that document favors the borrower except a small paragraph that says as soon as you pay the bank off, we'll give you a satisfaction of mortgage in a reasonable amount of time. That's it. Everything else favors the bank in the event you default. So those are, that's the note in the mortgage. And again, standard uniform instruments, you'll see at the bottom of each of those documents in the handout and at any closing that you go to. So nothing really changes except the borrower, the property that's being mortgaged, the amount of the loan, and the bank that's doing the lending. One of the biggest documents at the closing that the bank hands out that causes a lot of confusion is the good faith estimate. And the reason behind that, and if you look at the document, and I think there's one in the handout here. It's part of the loan application that's in there, the 1003. The problem with the good faith estimate is the confusion regarding the annual percentage rate. There's the first box that you'll see on the good faith estimate. It's an artificially inflated percentage rate that takes into consideration the closing costs associated with the loan. You'll get to a closing and your client will say, well, I'm expecting a 4% interest rate. You'll go through the documents, the note says that, the mortgage references it, the HUD-1 settlement references it, you get to the good faith estimate, and the first box that they see on this good faith estimate says the APR is 4.91. And the borrower is going to look at me and say, well, geez, I thought I was getting 4%. And I try to calm them down, let them know this is a totally different rate. It's artificially inflated, so to speak, based upon the amount of closing costs that are going into the loan today. The closer that number, the APR, is to your interest rate, the better, the less amount of garbage costs that have gone into your loan. It's good at the beginning of the process, not so much at the closing table, because if you're closing with Trustco Bank today and they have 4.91 as your APR, in the beginning of the process you could take your Trustco APR and go to HSBC, well, First Niagara now, any of the other local banks and say, listen, I want to take out this loan amount, what's your APR compared to what I have at Trustco, and you can do the comparison. Little does the everyday consumer know or why that APR is there. It's for shopping comparisons. That's the best way I can put it. It's the most confusing part of the good faith estimate, especially when you're at the closing table going through the documents. Your client expects to get a 4% interest rate, and they're staring at a 4.91 APR. Totally different, but what it does is show you how much money is going towards closing costs, how much money is going towards the actual purchase of the home, what you're rolling into the loan, and then they generate based upon that an artificial, an annual percentage rate. But causes a lot of confusion. If you're able to explain that to your client in a coherent fashion, good for you. It's kudos to you, because I've had accountants as clients that don't understand it. Anybody that deals with numbers every day, it's not the most easy thing to do when you're trying to get through the good faith estimate explanation. One of the last few items that we'll talk about is the 1003. That one is in your materials as well. The 1003 is a code term with the bank for the Uniform Residential Loan Application. Again, it's at the closing table. You have to re-sign it. Every borrower has to sign it for a number of reasons. Basically, there's two reasons. One, they understand that if there's a co-borrower, they're applying for joint credit. So if one person defaults, in essence, they both are defaulting, and they're responsible for making up any of the obligations with the note. And then second of all, the bank has you re-sign the loan application at the closing to make sure that you haven't overstated your assets or understated your liabilities. But it's information they've collected at the very beginning of the application process. So a lot of the information that you see within the document, especially on pages 2 and 3, where they talk about your assets and liabilities, a lot of times that those things have changed. People have paid off their credit cards, or they've come into a sum of money, an inheritance or something of that nature within the interim. As long as you haven't overstated your assets, you've made a misrepresentation on those numbers when you were first applying, as long as your client hasn't misrepresented to the bank in any of those fashions, they're okay to sign it. But again, a lot of times I'll be going through this, hey, my home phone number's not correct, or geez, they have my old address on there. Not the most important pieces of information. You want to be as accurate as possible when going through this, but the thing that they're keying in on is making sure that you had that $40,000 in the bank, that you can afford this new loan, and you haven't purchased any second or third homes in the interim that would throw off their evaluation of the loan process. But it's a form. Again, it has a lot of information in it. If you're not familiar with it on a daily basis, it can certainly throw you off. Take a few minutes to flip through it before you do a closing, and you can understand why the information's in there. It's background information that they took down when they first applied, credit report history, the assets and liabilities of your client, so they can do a good evaluation of what goes into the overall approval of this loan application. So it's signed in a number of places and submitted as part of the loan closing package.